invite you to relax and get comfortable. Join me in this discussion of Just Another Theory. Thank you for joining me on Just Another Theory podcast, where you can relax and we talk about true crime. It's been a while since I've been on the channel. However, with the changes that are taking place in the Avery case, I thought it was time that we get a little refresher course. And with that, I am going to share with you the read of the Notice of Motion and Third Motion for post-conviction relief pursuant to Wisconsin Statute 974.06 and 805.15. All right, let's get started. For those of you that would like to follow along, I have put a link down below, not only in the description of the video, but also posted in the comments pinned just for you. Please take notice that the petitioner, Stephen A. Avery, Mr. Avery, by and through his current post-conviction attorneys, Kathleen T. Zellner and Associates, PC, respectfully moves this court pursuant to Wisconsin Statute 974.06 for an order vacating the judgment of his convictions and sentence and ordering a new trial. In the alternative, he asks that this court grant a new trial in the interests of justice pursuant to Wisconsin Statute 805.15 or its inherent authority because of the real controversy was not fully tried. In support of his motion, Mr. Avery states as follows: Mr. Avery requests an evidentiary hearing and that he be produced for that hearing. Introduction. Two new witnesses have emerged in Mr. Avery's case with new and compelling evidence about a murder mystery that has intrigued a worldwide audience. The rush to judgment and tunnel vision that led to the arrest, prosecution, and conviction of Mr. Avery is exposed by the new witnesses who provide new and undisputable evidence that directly links Bobby Dassey, Bobby, to the murder of Teresa Halbach and the framing of Mr. Avery. Furthermore, the new evidence allows for a reconsideration of the real motive of this crime as being a sexual homicide, which was the culmination of an obsession by Bobby with viewing thousands of images of violent, deviant pornography. On October 31st, 2005, the obsessive fantasies of Bobby became a horrible reality when Teresa Halbach was brutally assaulted and murdered by 2 rifle shots to her skull. Her body was mutilated, as were many of the female subjects in the Dassey computer images. Bobby was in possession of the Halbach vehicle, which contained the crucial evidence of this terrible crime. Ms. Halbach's blood, key, electronic devices, and license plate, which was concealed in another salvage car, and Mr. Avery's carefully deposited blood on the seats, dash, and DNA on the hood latch. By being in possession of the vehicle, Bobby was able to control the direction of the investigation. He planted the vehicle on the Avery property after he deposited Mr. Avery's blood and DNA in it. He had Ms. Halbach's key and electronical devices, which ended up in Mr. Avery's bedroom and burn barrel. Bobby did all of this to exculpate himself and to frame his uncle, Mr. Avery. Mr. Avery does not have to prove who committed this terrible crime to receive relief. This is not his intent or purpose. However, he does have the right to prove he did not receive a fair trial. The new evidence, which establishes that Bobby meets all of the Denny criteria to be a third-party suspect, and the evidence of 2 Brady violations demonstrate that Mr. Avery was deprived of a constitutionally guaranteed right to present a complete defense to the charges against him. Statement of the case. Number 1. This case began in early November 2005 with the disappearance of Teresa Halbach, a 25-year-old professional photographer. Ms. Halbach was reported missing on November 3, 2005. Volunteer searchers found Mrs. Halbach's Toyota RAV4 on the 40-acre site of Avery's Auto Salvage and Salvage Yard business, where Mr. Avery and other family members lived and worked on November 5, 2005. Miss Halbach had photographed vehicles at the site previously, per Mr. Avery's request. According to state witness Bobby, Ms. Halbach was last seen walking toward Mr. Avery's trailer on October 31st, 2005. Number 2. After finding Mrs. Halbach's RAV4, law enforcement searched the Avery property and, over the course of the next 4 months, discovered and identified evidence including burned bone fragments in and around a burn pit with DNA matching Ms. Halbach's, Mr. Avery's, and Ms. Halbach's blood in the RAV4. The remnants of electronic devices and a camera, the same model as Mrs. Halbach's, in a burn barrel. Ms. Halbach's RAV4 key in Mr. Avery's bedroom, with Mr. Avery's DNA on it. Mr. Avery's DNA on the hood latch of the RAV4 deposited, the state later claimed, Mr. Avery's sweaty hands, and a bullet in Mr. Avery's garage containing Ms. Halbach's DNA. Procedural history. Number 1. Third-party suspects. Number 3. On July 10, 2006, before Mr. Avery's trial, the trial court entered an order entitled Order Regarding State's Motion Prohibiting Evidence of a Third-Party Liability. Denny motion. The order specified that if the defendant intended to, quote, to suggest that a third party other than Brendan Dassey is responsible for any of the crimes charged, the defendant must notify the court and the state of such intent at least 30 days prior to the start of the trial. The trial court further ordered that the defendant would be subject to the standards relating to the admissibility of any third-party liability evident pursuant to State v. Denny, 120, Wisconsin 2D. Number 4. In light of the court's order on January 10, 2007, Mr. Avery filed the defendant's statement on third-party responsibility. There, Mr. Avery stated that he did not kill Ms. Halbach and that there was, quote, at least a reasonable possibility that one or more unknown others present at or near the Avery salvage yard on the afternoon of October 31st, 2005, killed her. Mr. Avery identified several persons as potential alternative perpetrators: Scott Tadich, Andres Martinez, Robert Fabian, Charles and Earl Avery, and the Dassey brothers. Mr. Avery argued that Denny did not apply to the circumstance in his case and that as a result, he should not be bound by the 3-part test set forth in Denny. He further argued that even if Denny did apply to his case, he should be permitted to introduce evidence at his trial of several alternative perpetrators in this case. On January 30th, 2007, the trial court entered its decision and order on admissibility of third-party liability evidence. The court held that Denny's legitimate tendency test applies to any evidence the defendant wished to present regarding potential third parties who might have been responsible for Ms. Halbach's murder. The trial court found that in absence of motive, it certainly may be more difficult for the defendant to offer evidence which is relevant and material connecting a third party to the crime. The court simply finds nothing in the order made by the defendant that goes beyond the level of speculation. Roman numeral 2 verdict. Number 6. On March 18, 2007, Mr. Avery was convicted following a jury trial of first-degree intentional homicide, contrary to Wisconsin Statute 940.01, and a felon in possession of a firearm, contrary to Wisconsin Statute 941.29. The jury found Mr. Avery not guilty of mutilation of a corpse, 719.3. Roman numeral 3 post-conviction and direct appeal. Number 7. On June 29, 2009, prior post-conviction counsel filed a motion for post-conviction relief on Mr. Avery's behalf, pursuant to 809.30, seeking a new trial on grounds that, number 1, the trial court improperly excused a deliberating juror, and number 2, the trial court improperly excluded evidence of third-party liability. Number 8. On January 25, 2010, the motion for post-conviction relief was denied by the Honorable Patrick L. Willis in a written order. Regarding the issue of Bobby's third-party liability, Judge Willis found, quote, The only evidence offered by the defendant to show motive on the part of Bobby Dassey consisted of evidence allegedly supporting a motive to frame Stephen Avery. No evidence is offered to suggest Bobby Dassey had a motive to murder Teresa Halbach. Judge Willis concluded, the evidence offered against Bobby Dassey probably did meet the opportunity and direct connection to the crime requirements of legitimacy tendency tests because of his presence on the property at the time Teresa Halbach was there. However, without any showing of motive, third-party evidence against Bobby Dassey is precluded under Denny. Number 9. On December 14, 2011, the Wisconsin Supreme Court denied Mr. Avery's petition for review pursuant to 808.10. Number 10. On February 14, 2013, Mr. Avery filed his first and only pro se collateral post-conviction motion pursuant to Wisconsin Statute 974.06. The motion was denied by the Honorable Judge Angela Suckowitz on November 23, 2015. Number 11. On October 11, 2019, current post-conviction counsel appealed the circuit court's denial of Mr. Avery's second post-conviction motion and all of its supplements. He filed motions to stay and remand concerning 2 additional claims. At the appellate court's direction, Mr. Avery raised his claims in his motions to the circuit court as supplemental post-conviction motions. The circuit court denied his motions to supplement. On October 12, 2021, Mr. Avery filed a motion to stay and remand. The appellate court denied it. Roman number 4, the appellate court's July 28, 2021 decision. Number 12. On July 28, 2021, the appellate court issued a per curiam opinion upholding the circuit court's summary denial of Mr. Avery's claims raised in his 974.06 post-conviction motion, and 2 supplemental motions holding Mr. Avery's 974.06 motions are insufficient on their face to entitle him to a hearing. State v. Avery, 2022, Wisconsin. Roman numeral 5, petition for review. Number 13. On November 17, 2021, the Wisconsin Supreme Court denied Mr. Avery's petition for review. Roman numeral 6. The appellate court reserved Mr. Avery's ability to file a successive 974.06 motion on certain claims. Number 14. On April 12, 2021, during the pendency of Mr. Avery's appeal, Mr. Avery filed a motion with the appellate court to stay his appeal and remand for evaluation of a new claim. The appellate court acknowledged this claim, stating the following. On November 9, 2020, we notified the parties that this case had been submitted to the court for decision on briefs. On April 12, 2021, Avery filed another motion with this court to stay his appeal and remand for evaluation of a new claim. This court concerns an alleged Brady violation, the factual basis for which Mr. Avery obtained on April 11, 2021. Specifically, the claim is based on the affidavit of Thomas Zielinski, a Manitowoc motor route driver, who attests that days after Miss Halbach's death, while on his paper route in the early morning hours, he spotted a shirtless Bobby Dassey and an unidentified older man pushing Miss Halbach's vehicle down Avery Road towards the junkyard. Mr. Zielinski further attests that after he delivered the paper, Bobby Dassey attempted to block his exit, causing him to swerve and drive into a shallow ditch. Mr. Zielinski claimed to have called the Manitowoc Sheriff's Office later that day to report what he had seen, but was told they already know who did it. He also claims to have attempted to contact Avery's trial attorneys after season 1 of Making a Murder, but never heard back from them. Number 15. Further, in its July 28, 2021 opinion, the appellate court advised, when Avery filed this motion, we had already twice stayed his appeal, each time because he asserted that the new claims related to those previously litigated and that it would be most expeditious to resolve them as part of an instant appeal. By the time Avery filed this new motion, however, we had already evaluated the legal and factual basis for the claims already raised. We therefore were and are in the position to conclude that this newly raised Brady claim bears little or no relation to those claims already before us. This is instead a distinct issue for the Circuit Court should resolve on a standalone basis through a new Wisconsin Statute 974.06 motion. Avery's latest motion arrived while our decision on his appeal was forthcoming. It would be inefficient use of the court's resources to now and once again delay the appeal's resolution. We appreciate that Avery likely wishes us to consider this new Brady claim in the context of claims previously raised, but we must weigh that implicit consideration against those discussed above. Simply put, Avery's appeal cannot continue indefinitely. Accordingly, this decision operates as an order denying Avery's April 12, 2021 motion to stay and remand. If Avery wishes to raise this claim, he must file a new Wisconsin Statute 974.06 motion with the Circuit Court. Number 16. The Appellate Court reserved Mr. Avery's ability to file a successive 974.06 motion on the claim in his most recent filing concerning the new witness who came forth on April 11, 2021. Specifically, the Appellate Court instructed the following. As discussed below, we are not addressing Avery's most recent filing to this court. See our discussion of motion number 6, which seeks to directly connect Dassey to Halbach's murder. If Avery wishes to raise that claim, he will need to bring a new Wisconsin Statute 974.06 motion. That motion would need to survive both Escalona-Navarro scrutiny and to be found to have merit, in which case the evidence presented might supply the missing direct connection. In that event, the valet CD evidence might become relevant to showing Dassey's motive and might bear on whether Dassey is or should have been a viable Denny suspect. We express no opinion on the merit of any such 974.06 motion, as all such issues would be for the Circuit Court to decide in the first instance. Number 17. Regarding certain claims Mr. Avery raised in his motion to reconsider the Circuit Court's October 3, 2017 order denying his second post-conviction motion and its two supplements, the Appellate Court found that neither we nor the Circuit Court have squarely considered whether these claims are procedurally barred under Escalona-Navarro or whether Avery pled sufficient materials entitled him to a hearing. Such consideration would have to come on a separately filed Wisconsin Statute 974.06 motion, and we express no opinion as to whether such claims would be barred in the event such motion is filed. Thus, the new material that Mr. Avery raised in his motion to reconsider and its supplements were never ruled upon by the Circuit Court. Evidence supporting Mr. Avery's third 974.06 post-conviction motion. Number 1. Newly discovered evidence. New witness provides direct connection between Bobby and the Halbach murder and planting evidence to frame Mr. Avery. Number 18. Mr. Avery's new witness, Mr. Thomas Zielinski, Mr. Zielinski, contacted Mr. Avery's current post-conviction counsel in December of 2020. Mr. Avery had already filed his appeal on October 11, 2019. Mr. Zielinski stated that he had witnessed Bobby and one other individual, a bearded man, pushing Mrs. Halbach's RAV4 onto the Avery salvage yard in the early morning hours of November 5, 2005. Mr. Zielinski claimed that he had reported this information to the Manitowoc Sheriff's Office. Number 19. On April 11, 2021, Mr. Zielinski provided an affidavit to Mr. Avery's current post-conviction counsel stating the following. Mr. Zielinski was a motor route driver for Gannett Newspapers Incorporated and delivered papers to the Avery salvage yard in the early morning hours of November 5, 2005. Prior to delivering the newspapers to the Avery salvage yard, he turned onto the Avery property and witnessed two individuals, a shirtless Bobby Dassey, Bobby, and an unidentified older male, suspiciously pushing a dark blue RAV4 down Avery Road toward the junkyard. The RAV4 did not have its lights on. Mr. Zielinski drove past the two men and delivered newspapers to the Avery mailbox, and then he turned around and drove back towards the exit. When he reached the RAV4 still over there, Bobby Dassey attempted to step in front of his car to block him from leaving the property. Mr. Zielinski came within 5 feet of Bobby Dassey, and his headlights were on Bobby during this entire time. Then Zielinski swerved into a shallow ditch to escape Bobby and exit the property. Mr. Zielinski states in his affidavit that he called out, "Paperboy, gotta go," because he was afraid for his safety. He further stated that Bobby Dassey looked at him in the eye and did not appear happy to see Mr. Zielinski there. After Mr. Zielinski learned that Teresa Halbach's car was found later in the day on November 5th, 2005, he realized the significance of what he observed and immediately contacted the Manitowoc Sheriff's Office. Number 20. The Zielinski evidence provided by Mr. Zielinski to Mr. Avery's current post-conviction counsel is newly discovered evidence which provides the missing direct connection between Bobby and Miss Halbach's murder, making him a Denny suspect. Number 21. The discovery of new evidence may constitute a sufficient reason for a second or subsequent post-conviction proceeding under Wisconsin Statute 974.06. To prevail, however, the movement must carry the burden of proving that the evidence at issue is newly discovered. In most cases, to obtain relief based on newly discovered evidence, a convicted person must establish by clear and convincing evidence that 1. The evidence was discovered after conviction, and number 2, the defendant was not negligent in seeking evidence. Number 3, the evidence is material to an issue in the case. And number 4, the evidence is not merely cumulative. If the person satisfies those 4 requirements, then the circuit court must determine whether a reasonable probability exists that a different result would have been reached in a new trial. Number 1. The Zielinski evidence was discovered after Mr. Avery's conviction. Number 22. Mr. Avery did not have the Zielinski evidence before Mr. Zielinski came forward to Mr. Avery's current post-conviction counsel in April of 2021. Mr. Zielinski attempted to contact the Innocence Project and not Mr. Avery's trial defense counsel via email in 2016 regarding the evidence he had, to no avail, and had not previously provided it to Mr. Avery's counsel. Rather, the Zielinski evidence was reported to the Manitowoc Sheriff's Office by Mr. Zielinski, but the evidence was suppressed from Mr. Avery by the prosecution. Number 2. Mr. Avery was not negligent in seeking the evidence. Number 23. Neither Mr. Avery nor his counsel were on notice that Mr. Zielinski had any knowledge about Bobby's actions on November 5th, 2005. Subsection number 3. The evidence is material to an issue in Mr. Avery's case. Number 24. The Zielinski evidence is material to several issues in Mr. Avery's case. Most importantly, it is material for establishing Mr. Avery's defense, that is, that a third party committed the crime against Ms. Halbach. It is material for establishing the direct link to Bobby as a third-party Denny suspect and to opening the door to reconsidering the Vele CD as establishing a sexual motive for the murder. Additionally, the Zielinski evidence is material to the evidence in the RAV4 being planted by Bobby, including Mr. Avery's blood and DNA. The RAV4 also contained the Halbach vehicle key and Ms. Halbach's electronic devices, which were discovered in Mr. Avery's bedroom and burn barrel, respectively. Further, the Zielinski evidence is material to impeach Bobby's trial testimony that Ms. Halbach never left the Avery property and that she was last seen walking towards Mr. Avery's trailer. Number 25. Bobby was the state's primary witness against Mr. Avery. During his opening statement, Prosecutor Kratz explicitly informed the jury of the significance of Bobby's punitive observations on the date of Miss Halbach's disappearance. You are going to hear that Bobby Dassey was the last person, the last citizen that will have seen Teresa Halbach alive. Bobby's testimony was the most determinative of Mr. Avery's guilt because the state used it to establish that Miss Halbach never left the Avery property alive. Number 26. At trial, Bobby testified that he observed Mrs. Halbach's light green or teal-colored SUV pull up in his driveway at 2:30 p.m. on October 31st, 2005. Bobby then observed Mrs. Halbach exit her vehicle and start taking pictures of his mom's maroon van right in front of his trailer. Bobby testified that he then observed Miss Halbach walking towards the door of Mr. Avery's trailer. Number 27. The following exchange occurred between Prosecutor Kratz and Bobby. Question. After seeing this woman walking toward your Uncle Stevens, did you ever see this woman again? Answer. No. Applicable law, re Denny. Number 28. When a defendant seeks to present evidence that a third party committed the crime for which the defendant is being tried, the defendant must show, quote, a legitimate tendency that the third party committed the crime. In other words, that the third party had motive, opportunity, and a direct connection to the crime. State versus Denny. Number 29. To support the introduction of a third-party perpetrator evidence, there must be a legitimate tendency that the third party could have committed the crime. The defendant need not establish the guilt of the third party to the level that would be necessary to sustain a conviction. However, evidence that simply affords a possible ground of suspicion against another person should not be admissible. Number 30. The legitimate tendency tests ask whether the pro-offered evidence is so remote in time, place, or circumstance that a direct connection cannot be made between the third person and the crime. The Denny requirements are now satisfied. A. Bobby's motive to commit the murder of Teresa Halbach. Number 31. Under the motive prong, the court must question whether the alleged third-party perpetrator had a plausible reason to commit the crime. Number 32. A defendant's motive to commit a homicide is widely considered to be relevant. The admissibility of evidence of a third party's motive to commit the crime charged against the defendant is similar to what it would be if that third party were on trial himself. Number 33. Other acts' evidence may be admitted when offered for other purposes, such as proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident, Wisconsin Statute 904.04. Number 34. Law enforcement considered pornography as evidence of motive in Miss Halbach's murder. The clear working theory of the investigators was that the murder of Miss Halbach was motivated by a sexual assault. Pursuant to that theory, the Dassey computer was seized by law enforcement on April 21, 2006. Number 35. Evidence of Bobby's motive to commit Mrs. Halbach's murder is contained on the hard drive of the Dassey computer, namely, the material contained on the Belly CD. The appellate court acknowledged this evidence could be relevant for establishing the motive element of the Denny test if the new evidence directly connected Bobby was raised. Specifically, the appellate court stated the evidence, Zielinski's evidence, presented might supply the missing direct connection. In that event, the Belly CD evidence might become relevant to showing Dassey's motive and might bear on whether Dassey is or should have been a viable Denny suspect. Number 36. Detective Belly's forensic examination of the Dassey computer searched for specific words the user had searched. Detective Belly selected the specific words and conducted a search for those words. There were 2,632 search results for the following words: blood, 1, body, 2,083, bondage, 3, bullet, 10, cement, 23, DNA, 3, fire, 51, gas, 50, gun, 75, handcuff, 2, journal, 106, MySpace, 61, news, 54, rev, 74, stab, 32, throat, 2, and tires, 2. These selected words establish a direct link between the specific evidentiary items related to the Halbach murder and the searches performed on the Dassey computer. The Belly CD contains the state's, quote, recovered pornography images relevant and material to the Halbach murder. The Belly CD refined the 14,099 images on the 7 DVDs that the trial defense counsel received in discovery and recovered 1,625 violent pornography images which had been deleted. The, quote, recovered porn depicted violent images of the torture and mutilation of young females. Number 37. Brad Dassey, Barb's stepson and the half-brother of Brian, Bobby, Blaine, and Brendan, avers that he had a conversation with Barb in which she indicated that she had hired someone to remove evidence from the Dassey computer. The authorities interviewed Brad after he reported this information, but he was not called as a witness by either side to testify at Mr. Avery or Brendan's trials. This is corroborated by the law enforcement report, which states that on June 6, 2006, Special Agent Fassbender and Investigator Wiegert interviewed Brad, who provided this information about the Dassey computer deletions. Number 38. The new forensic examination of the Dassey computer corroborates the affidavit of Brad. Mr. Hunt, in his computer examination, detected 8 periods in 2005, close to the date of the murder, for which files are missing and, quote, presumably deleted from the Dassey computer. August 23rd through 26th, August 28th through September 11th, September 14th through 15th, September 24th through October 22nd, October 23rd through 24th, October 26th through November 2nd, November 4th through 13th, and November 15th through December 3rd. Number 39. In reviewing images contained on the Veli disk, Special Agent Thomas Fassbender made the following observations. Number 1. Photos of both Teresa Halbach and Stephen Avery with an apparent date of April 18, 2006. Number 2. There were numerous images of nudity, both male and female, to include pornography. The pornography included both heterosexual, homosexual, and bestiality. There were images depicting bondage as well as possible torture and pain. There was also text images with the name Emily. There were images depicting potential young females to include an infant defecating. There were images of injuries to humans to include a decapitated head, a badly injured and bloodied body, a bloodied head injury, and mutilated body. And number 3, the disc received from Detective Veli as well as the hard copy pages of instant message conversations were maintained in S.A. Fassbender's possession. Number 40. There is sufficient evidence that it was only Bobby who had access to the Dassey computer during the day on weekdays between approximately 7 a.m. and 3:30 p.m. Barb's work schedule was from 6 a.m. until 4:30 p.m. every day, Monday through Thursday of every week. Brendan and Blaine would get picked up by the school bus at the Avery Road between 7:08 a.m. and 7:13 a.m. and dropped off at the same place between 3:30 p.m. and 4 p.m. Therefore, Barb, Blaine, and Brendan, the 3 other individuals living at the Dassey residence, are excluded from even having access to the Dassey computer at the times most of the violent searches occurred. Number 41. Moreover, 128 searches for the most violent porn images primarily occurred weekdays when only Bobby was at the Dassey residence. It is undisputed that Mr. Avery never accessed the Dassey computer. He did not have the password for the Dassey computer, nor did he possess a key to the Dassey residence, which was locked when no one was home. The only time Mr. Avery ever entered the Dassey residence was when one of the Dassey family members was home. Mr. Avery worked at the Avery salvage yard during the weekdays from 8 a.m. till 5 p.m. Moreover, Mr. Avery would be eliminated from all but 15 of the 128, 11.7%, searches for the most violent porn images at issue simply by having been arrested on November 9, 2005. Brendan would be eliminated from all but 26 of the 128, 20.3%, searches for the most violent porn images at issue simply by having been arrested on March 1st, 2006. Number 42. Bobby testified that on October 31st, 2005, he was the only person home between 6:30 a.m. and when he claims he left to go hunting at 2:45 p.m. Therefore, it is undisputed that Bobby was the only person home on October 31st when searches were made on the Dassey computer at 7 a.m., 9:33 a.m., 10:09 a.m., 1:08 p.m., and 1:51 p.m. prior to Miss Halbach's arrival at the Avery salvage yard. The timing of these internet searches on October 31st directly contradicts Bobby's trial testimony that on that day he was asleep from 6:30 a.m. to 2:30 p.m. Number 43. On November 17, 2017, in an interview with Bobby by state investigators, Bobby claimed that the Dassey computer was located, quote, on a desk in the living room at that time. When Bobby was asked if the Dassey computer was ever located in his bedroom, he stated, quote, it was not. Bobby's statement is directly contradicted by the crime scene footage taken by Sergeant Tyson on November 12, 2005, which shows the Dassey computer was located in Bobby's bedroom. Bobby's statements are further contradicted by his brother Blaine, who stated in his affidavit to current post-conviction counsel on June 25, 2018, that the Dassey computer was located in Bobby's room, and Bobby was the primary user of it. Number 44. Wisconsin Statute 904.04 provides that evidence of other crimes and or wrongs and or acts when offered as proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident is admissible. Number 45. The depicted acts in the violent pornography Bobby was viewing are sufficiently similar to the violent murder of Miss Halbach. Number 46. The evidence of Bobby's searches for violent pornography images is not so remote in time as to be inadmissible, but rather so close in time to Miss Halbach's murder that the searches are direct evidence of Bobby's motive to kill Miss Halbach. Number 47. The 1,625 previously deleted but recovered images of violent pornography could have established motive for trial defense counsel's Denny motion. The court in Dressler v. McCarthy held that the, quote, acts committed pursuant to 904.04 were the defendant's possession of the pornographic videotapes and pictures. Those images depicting intentional violence were admitted as evidence of the defendant's motive, intent, and plan to murder the victim. Number 48. The defendant in Dressler argued that the videotapes and pictures were irrelevant and constituted inadmissible propensity evidence. The Seventh Circuit disagreed, stating the fact that the defendant maintained a collection of videos and pictures depicting intentional violence is probative of the state's claim that he had an obsession with that subject. A person obsessed with violence is more likely to commit murder, and therefore the videos and photographs are relevant. Number 49. The Dressler court held that although evidence of the general character of the defendant is inadmissible to prove he acted in conformity with therewithin, the above exception from 904.04 was deemed to apply. Number 50. Dressler is persuasive authority that the same result should occur here. Mrs. Halbach was killed in a violent manner. Maintaining the violent porn images is probative to establish that Bobby had an obsession with violence and therefore was more likely to commit murder. The violent porn images are relevant to Bobby's motive and would have resulted in trial defense counsel being able to establish his motive for Mrs. Halbach's murder to meet the Denny standard. Number 51. As Mr. Avery, sexual homicide expert, Ann Burgess, Ph.D. Dr. Burgess, opines in her affidavit submitted previously to this court, there is a well-established causal connection between pornography consumption and violent behavior. Number 52. In Mr. Avery's motion to reconsider this court's prior decision, former FBI agent and police procedure expert Greg McCrary, Mr. McCrary, submitted an affidavit wherein he described his opinion that the searches for violent underage and child pornography, combined with the images of and searches for dead bodies, quote, reflects a comorbidity of sexual paraphilias. It is the opinion of Mr. McCrary that Bobby Dassey was becoming obsessively deviant in his viewing of violent pornography in the weeks before Miss Halbach's murder. B. Bobby's opportunity to commit the murder of Teresa Halbach. Number 53. The second prong of the Denny test, the opportunity prong, asks, could the alleged third-party perpetrator have committed the crime, directly or indirectly? And in other words, does the evidence create a practical possibility that the third party committed the crime? Number 54. As a legal concept, opportunity appears in the Wisconsin statutes in the context of, quote, other acts, evidence. Other crimes, wrongs, or acts, evidence of other crimes, wrongs, or acts is not admissible to prove the character of a person in order to show that the person acted in conformity therewithin. This subsection does not exclude the evidence when offered for other purposes, such as proof of a motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. Number 55. The case law, as well as 904.04, permits the introduction of other acts evidence to show a person's whether a party or third person, quote, opportunity to engage in certain conduct. Opportunity is a broad term. Proof of opportunity may be relevant to place the person at the scene of the offense, time, and proximity, or to prove whether one had the requisite skills, capability, or ability to carry out an act. It is incumbent on the proponent, however, to show the relevance of the opportunity evidence. Number 56. According to the trial court, Mr. Avery's trial defense counsel has already established that Bobby had the opportunity to commit the murder of Miss Halbach. The Zielinski evidence greatly strengthens the opportunity argument because Bobby is in possession of Miss Halbach's vehicle where her murder likely occurred. C. Bobby's access to items of evidence to frame Mr. Avery. Number 57. Additionally, the defense theory was that Mr. Avery was framed by evidence being planted in Miss Halbach's car and Mr. Avery's trailer and burn barrel. Number 58. The Zielinski evidence that Bobby was in possession of Miss Halbach's vehicle provides the opportunity access to the items that were used, quote, in the frame-up. State v. Wilson, 2015. The specific items that were planted and used in the frame-up of Mr. Avery were Mr. Avery's blood in Miss Halbach's vehicle, Miss Halbach's RAV4 key in Mr. Avery's bedroom, and Miss Halbach's electronic devices in Mr. Avery's burn barrel. D. Bobby had access to Mr. Avery's blood. Number 59. Mr. Avery told law enforcement in a recorded interview that his finger, which had been cut open prior to October 31, 2005, rebled on November 3, 2005, and dripped blood in his bathroom sink and on the bathroom floor. In Mr. Avery's trial, Raleigh Johnson, the owner of Mr. Avery's trailer, testified he observed that the cut on Mr. Avery's finger was present prior to October 31, 2005. Mr. Avery consistently expressed his belief to his attorneys and the media that his blood found in Mrs. Halbach's vehicle was planted and that it came from his bathroom sink. Number 60. Mr. Avery's claim that he bled into his bathroom sink and on the floor was corroborated by the fact that law enforcement found some of the blood around his bathroom sink and on his bathroom floor. Number 61. In the early evening of November 3, 2005, Sergeant Andrew Colborn, Sergeant Colborn, came to the Avery salvage yard and spoke to Mr. Avery. After meeting with Sergeant Colborn, Mr. Avery went to his vehicle and drove to the Dassey residence. Barb, Blaine, and Bobby were home at that time. Number 62. Mr. Avery provided an affidavit on June 29, 2018. He stated the following in his affidavit regarding the events of the evening of November 3, 2005. I stopped at my sister, Barb Dassey Yonda's, Barb property, and broke open a cut on the outside of the middle finger of my right hand as I was attempting to unhitch her trailer for her. I went to Barb's store to see if any of her sons wanted to go with me to Menards. Bobby and Blaine were home. I asked Bobby and Blaine if they wanted to go with me and my brother Chuck to Menards. I told both of them that a law enforcement officer had just left the property after asking me questions about Miss Halbach's visit to photograph Barb's van on October 31, 2005. I noticed that Bobby was immediately nervous after I mentioned the visit by the officer. He said that he could not go with me to Menards and that he had, quote, things to do. There is no doubt in my mind that Bobby saw that my finger was bleeding. My memory is that Blaine said that he wanted to go to Menards, and he went with Chuck and me. Prior to leaving for Menards, I returned to my trailer to put tape on my bleeding finger. A large amount of blood dripped onto the rim and sink and the floor of the bathroom. I did not wash away or wipe up because Chuck was waiting for me to go to Menards in Manitowoc with him. While we were leaving Avery property driving a flatbed to Menards in Manitowoc, I saw taillights in front of my trailer. The taillights were further apart and higher off the ground than sedan taillights. I told my brother, who was driving, about the taillights. We turned around and drove to my trailer, but the vehicle was gone. On November 4th, I woke up at 6 a.m. and went into the bathroom to take a shower. I saw that most of the blood on my sink, which I had not cleaned up the previous night, was gone. It seemed to me that the blood had been cleaned up. After reviewing more case documents and thinking about what happened on November 3rd, 2005, I do not believe that law enforcement broke into my trailer and took blood from my sink and planted it in Ms. Halbach's vehicle. Number 63. According to Mr. Avery, he left the door unlocked when he went to Menards. However, the Dasseys also had a key to his residence. Number 64. Mr. Avery told law enforcement and trial defense counsel that as he was leaving his property around 7 p.m. on November 3rd, 2005, and exiting on to Highway 147, he observed taillights of a vehicle close to his trailer. Mr. Avery also told trial defense counsel that he noticed that his blood had been removed from his sink when he entered his bathroom early in the morning on November 4th, 2005. E. Bobby's direct link to the murder of Miss Halbach. Number 65. The third and final prong of the Denny test asks whether there is evidence that the alleged third-party perpetrator actually committed the crime directly or indirectly. Number 66. The Zielinski evidence demonstrates that Bobby could have committed the murder because he is in possession of Miss Halbach's vehicle, where the murder likely occurred as evidenced by Miss Halbach's blood in the vehicle. The vehicle is a key piece of evidence in the crime. Number 67. The new evidence that Mrs. Halbach's vehicle was returned to the Avery salvage yard from a different location is corroborated by the fact that a witness saw a vehicle similar to Mrs. Halbach's leave the property on October 31st. In Mr. Avery's trial, Mr. Le Guin, a propane driver, testified that he saw a green, mid-size SUV leaving the Avery salvage yard driving towards Highway 147 between 3:30 and 4 o'clock p.m. on October 31st. He informed law enforcement about this when he was stopped at a roadblock a few days later and had heard about the news of Miss Halbach being missing. Number 68. Further, it is corroborated by Bobby's brother Blaine's account on June 25, 2018. Bobby's brother Blaine provided Mr. Avery's current post-conviction counsel with an affidavit attesting. On October 31, 2005, when the school bus driver brought Blaine and me home as we traveled on State Highway 147, I saw Bobby on State Highway 147 in a bluish or greenish vehicle heading towards Mishcot. Bobby was not driving his black Blazer. Bobby was not home the rest of the evening while I was home. Bobby's trial testimony contradicts Blaine's affidavit because Bobby testified that he was home at 5 p.m. Number 69. Bobby was with Michael Osmundson when Mrs. Halbach's vehicle was discovered on November 5, 2005. Current post-conviction counsel investigator met with and interviewed Osmundson about whether he was the individual with Bobby pushing the RAV4 onto the Avery salvage yard. The interview was conducted because Osmundson fit the height, weight, and beard description provided by Mr. Zielinski of the individual helping Bobby push the car. When Osmundson was asked if he was the individual who helped Bobby push the vehicle on the Avery salvage yard on November 5, 2005, Osmundson responded that he could not remember if he was that individual. Number 70. Further evidence of Bobby's dishonesty. Bobby never reported to law enforcement the alleged statement Mr. Avery said to Bobby and Osmundson about, quote, whether they wanted to help him get rid of a body. Combined reports re-interviews of Bobby Dassey. This was a major issue at trial. Trial defense counsel moved for a mistrial, pointing out that they had never been apprised of Bobby's new claim. During Bobby's direct examination, Prosecutor Kress asked Bobby, "Now, Bobby, on the 3rd of November, that would have been a Thursday, I believe, do you recall having a conversation with your uncle Stephen regarding a body?" And Bobby responded, "Yes." On cross-examination, Bobby testified that Mr. Avery stated this remark about getting rid of a body in jest on November 3rd, 2005, when he and Osmundson were in the garage. However, Osmondson told law enforcement that Mr. Avery made such a statement to them on Thursday, November 10th, 2005. The only time Osmondson was at the Dassey residence between October 31st and November 11th, when he and Bobby were inside the Dassey garage and Mr. Avery came over. This claim is unequivocally false since Mr. Avery was arrested on November 9th, 2005. Number 71. Remarkably, Osmondson stated to law enforcement that he first learned about the missing girl on Tuesday, November 1st, 2005, when Miss Halbach had not yet been reported missing. Number 72. Further, the record reveals that Osmondson and Bobby were either suspiciously calling each other repeatedly or with each other at relevant times after Miss Halbach's murder. Bobby's phone records reflect that on October 31st, 2005, there were 7 phone calls between Bobby and Osmondson occurring between the following times in the morning and evening: 6:12 a.m., 6:36 a.m., 3:56 p.m., 3:57 p.m., 4:53 p.m., 5:10 p.m., and 6:01 p.m. Bobby's phone records reveal that Bobby called Osmondson a total of 66 times from October 24th, 2005 to November 9th, 2005. Number 73. The Zielinski evidence is newly discovered and directly links Bobby to Miss Halbach's murder because, as previously stated, Miss Halbach's RAV4 was a key piece of evidence in her murder. Number 4. The evidence is not cumulative. Number 74. The Zielinski evidence provides for the first time the, quote, missing direct connection to Bobby as a third-party suspect for Mrs. Halbach's murder and is therefore not cumulative. Number 75. If the defendant satisfies all 4 criteria of newly discovered evidence, the reviewing court then examines whether it is reasonably probable that, had the jury heard the newly discovered evidence, it would have had a reasonable doubt as to the defendant's guilt. This presents a question of law. A reasonable probability of the different outcome exists if there is a reasonable probability that a jury, looking at both the old evidence and the new evidence, would have a reasonable doubt as to the defendant's guilt. Number 76. Overwhelming evidence against the defendant may not serve as a basis for excluding evidence of the third party's opportunity or direct connection to the crime. By evaluating the strength of only one party's evidence, no logical conclusion can be reached regarding the strength of contrary evidence offered by the other side to rebut or cast out. Number 77. If Bobby is established as a viable third-party Denny suspect, the forensic evidence in this case is completely undermined. The newly discovered evidence that Bobby was in possession of Miss Halbach's vehicle means that he had opportunity and access to plant evidence in the vehicle and from the vehicle. Because Bobby has been directly linked to the murder of Miss Halbach, there's a reasonable inference that he planted the bones in Mr. Avery's burn pit. Number 78. This new evidence creates a reasonable probability that, had the jury heard the new evidence, it would have had a reasonable doubt as to the defendant's guilt. Therefore, Mr. Avery should be granted a new trial. This has been just another theory, and that was part 1. If you would like to continue, we're going to do Brady violations, read the Zielinski evidence, beginning in part 2. Thank you so much, and you have a wonderful night. Make your day count. Love ya. To the moon and back.